Good morning and afternoon, everyone. My name is Aaron Garrell, and welcome to our 1601st Justice Clearinghouse webinar, Practical Access to Victims' Rights. Victims' rights are recognized nationwide and begin when crimes are reported to law enforcement. And during our webinar this morning, we'll explore how early law enforcement contact can shape a victim's access to those rights, highlighting common protections, how they're applied in the field, and examples from different jurisdictions. We do have two presenters for you this morning. Meg Garvin is the Executive Director of the National Crime Victim Law Institute and a clinical professor of law at Lewis and Clark. She's a nationally recognized expert on victim rights, has advised Congress, the military, and numerous national organizations on justice system reform. And we've got Amy Durall back, who is currently a fellow with the Office for Victims of Crime, OVC. The fellowship centers on law enforcement response to victims and law enforcement-based victim services. Prior to joining OVC, Amy served as a senior project manager with the International Association of Chiefs of Police. And now, briefly, before we begin, I'd like to share with you some information about Justice Clearinghouse. The Justice Clearinghouse is the only peer-to-peer multidisciplinary educational program for justice professionals that offers the instruction and skills necessary to achieve both individual and organizational transformation. Through our year-round virtual conference, our audience and members develop those critical skills that are necessary to positively impact themselves and their communities. And while anyone can attend our live events, our paid members are able to access our content on their own schedule, with over 1,500 recorded webinars, and are also eligible to receive certificates of attendance that may be used when seeking continuing education credits. So if you're not presently a member, I would invite you to join today and support our work. The last couple of things I would like to address with everyone is some basic housekeeping items. First, this event is being recorded and the formal presentation is scheduled to last about 60 minutes. It'll be available to members on the Justice Clearinghouse website. Second, this is a listen-only event, but you can type in any questions you have for our presenters through the Zoom toolbar, and we'll take as many of those questions as possible at the end of the formal presentation. Now, of course, given the remote nature of webinars, Amy and Meg aren't going to be able to read your body language, so feel free to use those emojis in the Zoom toolbar under React to let them know how you're feeling about the information you're sharing. Now, we do have several polling questions incorporated into this webinar. It's going to be a very interactive webinar. I'm going to ask that first question. We just wanted to know, how are you participating in today's webinar? Is it from a PC, tablet, smartphone, or by conference call? I mentioned the interactivity of this webinar, if that's a word. I earlier shared just a few minutes ago a handout, Practical Access to Victim Rights Scenarios. We're going to be relying on that heavily during the webinar. So after you get the polling question answered, please feel free to download that either from chat, or I also included a link where you can find that. All right, I'm going to go and end the poll. I'll share the results. 89% of you are on a PC, 9% are on a smartphone, 1% tablet, and no one is connected by voice only. That's fantastic. Finally, after today's webinar, there is going to be a follow-up survey, and we ask that you complete it. Your feedback is shared with our presenters and helps shape everything we do here at Justice Clearinghouse. With that, I'll go and turn the presentation over to our first instructor for this morning. Amy, it's all yours.
Great, thanks, Aaron. I am excited about this conversation today. Victims' rights has been kind of a nebulous area for me during my whole career working in law enforcement victim services. I have always understood how vitally important victim rights are, but we tended to have a very clumsy way of recognizing how to introduce those rights, how to give people access to those rights. And so for me, I'm excited about this presentation because we're going to kind of envelop those in a scenario-based conversation. And hopefully people can pull out of that and recognize that rights are really counterparts to services, right? It's the gateway to getting people great services if you give them access to their rights. And so hopefully that's what we can pull out of this conversation today. Like Aaron mentioned, it's going to be pretty interactive. So if you want that scenario pulled up on a second screen or quickly printed out, we're going to be doing mostly scenario-based work today. And then there's going to be several polls that hopefully engage you and help you kind of work through how to recognize rights as you step through law enforcement processes. So let's just jump into just some basic concepts, right? So what we know about victims' rights is that they exist in all 50 states and the federal government. And law enforcement agencies have some responsibilities around victims' rights. What I have typically seen working with law enforcement agencies is they focus on handing out a pamphlet. And the reality is, from my perspective, victims and co-victims deserve much more than that. Those rights show up in multiple places, not just at that first report. And so we need to do a much better job of getting them access to those rights as we progress through our actions when we're involved in law enforcement processes. But law enforcement agencies, both at federal and there are federal and state statutes, and they typically provide information about rights, services, and processes that people have access to. Um, Most state statutes include an expectation to provide information, but don't really specify which agency personnel hold that responsibility, right? And so if you are an agency fortunate enough to have victim service personnel, you're in a really good spot to have those personnel really focus in on how to lift up those rights and the access to those rights. But what I will say is that all agency personnel have some responsibility to making sure that those rights are accessible to people. So I'm going to flip it over to Meg, and she's going to kind of walk through just some foundational rights that are typically accessible during law enforcement contact, and then we'll jump into a scenario.
Great. Thanks, Amy. And I'm excited for this conversation too. I am, at my core, what I do on a daily basis is I'm an attorney for victims, helping them activate their rights. And why I'm excited for this conversation and always excited to partner with Amy is what we've learned over 40 plus years of victim services and victims' rights is that if law enforcement gets it right, then both the case goes well and the survivor has a better chance to thrive after their victimization. So this space of upstream working with law enforcement, you are the starting point. So what are the most common things that we need to know? That's what I'm going to do. I'm going to give us a baseline. So baseline, who has victims' rights? I can't answer it, right? And here's why. I can't answer it because you need to go look at your jurisdiction's laws because victim is a legal term of art that is defined in each jurisdiction. I can give you the broad swath, and that is a person directly harmed, right? As well as usually their family members, a caregiver, and in the cases of a homicide, it'll expand much broader than that. But the key is really looking at your law and finding where does it say a victim is, right? And defines it. There are jurisdictional differences for every definition of victim and jurisdictional differences around the rights. So everywhere in this country will have the rights that I'm about to cover, but they might use slightly different words. They might say they attach at slightly different times. And so what we're going to give you again is really level setting. We're going to go through some of the most common rights. And you might be thinking, that's not true here in Oregon, which is where I'm based. And great, that means you already know something, but someone else might be like, I don't know if that's true. Go look it up or reach out for technical assistance and we can help you. All right, so what are the ones we're going to cover? Again, at a very high level. We're going to really, again, just focus on rights when there's law enforcement contact. So 3 per screen are going to come up and we're going to talk about those. So compensation. Really want to be clear here. A victim does not have a right to crime victim compensation. What they have is a right to apply for crime victim compensation. Every jurisdiction will have a state-run crime victim compensation program that receives some funds from the federal system out of the Victims of Crime Act, but then the state administers those, and victims can apply to have reimbursement for certain costs that they incurred as a result of their victimization. It's going to be limited to violent crimes usually, not property crimes, and generally property isn't going to be covered, but compensation programs cover a lot so that survivors don't have to carry the financial burden of the victimization. Important to know, right? You don't need a conviction to access crime victim compensation. You don't even need a prosecution. Super important for law enforcement to know. The right to confer, or in some jurisdictions, the right to consult, it'll be phrased as the right to confer or consult with the attorney for the government or something similar. So you might be thinking, wait a second, why does that apply to law enforcement? Well, law enforcement is often the conduit between the victim and the prosecutor, right? And that becomes really important. And in order for a victim to be able to communicate effectively with the prosecution, they're going to have received information from law enforcement so that they know the types of questions and conversation to have with prosecution. So it's a really important one for law enforcement to be aware of. And then every jurisdiction will have a right that's phrased pretty broadly, something like the right to be treated with fairness, dignity, and respect for a victim's privacy, or something that says just the right to fairness and dignity, or respect for one's dignity, right? All these big words. And sometimes in daily practice, we think, what? What does that even mean? Well, in law, it means a lot. Fairness actually has a long legacy to mean I get to know when things are happening, what's happening, and I get to know all of that far enough in advance that I can prepare. That's fairness, right? In the legal, another legal word, due process, right? Procedural due process. So much in those big buckets that actually informs this next slide, because if you don't know those big bucket rights, none of the rest of these matter, right? So information, that one's pretty straightforward, right? It attaches at law enforcement because law enforcement will have an obligation to provide information both about the rights and the procedures of criminal justice to the victim. That goes beyond the brochure, like Amy said. So really start to understand the rights and the procedures. The right to be notified, it's often phrased as the right to be notified of certain court proceedings or public court proceedings, but actually courts have interpreted it to mean to receive notice of any critical phase of criminal justice. That's going to include release, right? Things that are in law enforcement's bucket. The right to privacy, this is a huge one. NCBLI does day and 2-day long trainings on the victim's right to privacy. But what's important from a law enforcement perspective is that you know it attaches, which means you have to be thinking about how reports are drafted, how your department responds to public records requests, how you label things, right? All of that, it really attaches. And so it becomes really important. 3 more that we wanted to flag for you. And again, we're just level setting. So when we get to the scenario, you have some vocabulary. Property. A victim has a right to prompt return of property that's been taken by law enforcement when it's no longer needed as evidence in a case. This is one that survivors are going to ask about a lot because sometimes our emotions are attached to our property. And so the return of something can really help with my surviving. And so get to know your own policies, procedures around this, and know that there's a right to the return. The right to protection, it's generally phrased in law as the right to be protected from the accused or those acting on behalf of the accused. This is going to interact with law enforcement because the victim's going to need to know a lot of information about where the accused is, right? When are you talking to the accused sometimes? All of those pieces so that my right to protection can have more meaning, let alone later at release condition hearings. And then the right to a support person. In some jurisdictions, this is literally phrased as the right to a support person. Sometimes that says a right to a support person in a law enforcement interview, in a law enforcement conversation, to court. Other times, it doesn't explicitly say the right to a support person, but the law has interpreted all those other rights to say that you can have a support person with you when you're trying to navigate these systems. There's a lot behind that, and happy to do some TA with you all about what that can mean in terms of, is the support person a witness? Are they not a witness? Those kind of things. But it's important to know because we want survivors to be supported as they interact with us, particularly with law enforcement. Then 2 big ones that we wanted to just name so that you had them as we go through the scenario, and also so you don't forget them. These are true regardless of where we are in criminal justice. Victims have rights. If a victim cannot understand those rights, we have not actually afforded them their rights. This comes from a long tradition of understanding the rights of an accused, right? Defendant's rights. The US Supreme Court and other courts have recognized that in order for a defendant who does not speak English to be able to access their constitutional and statutory rights, they will need an interpreter. There is no legal difference for a victim. So we are going to need to make sure that we're affording interpreters when victims have rights at issue so they can understand them. And then the last thing is wonderfully in the last really 30 years, we have started to recognize that victims can and often should have an independent lawyer helping them navigate the criminal justice system. The U.S. Department of Justice includes in its notifications to victims when they are notifying them that they are a victim, that they can retain a lawyer, right? Have a lawyer so that they can separately understand their rights. That's the core of NCBLI's mission, and we're always happy to help connect folks with no-cost lawyers. That's the landscape before we go into the scenario. I know it's a lot, but we also know this is just a refresher for most of you. Amy.
And I was going to just say, Meg, how did you feel cramming all of that into 10 minutes? Right? So, what I will say is that victims' rights is important, and it's taken me a long time in my career to kind of go through nuanced application, figure out how to change our practices to get more access to them. So, don't think that this one webinar is going to do it for you. You really have to dive in and engage. So, now we're going to jump into the scenario. You're going to be hearing my voice a lot as we read out the scenario, and then you guys are going to be prompted to start making some decisions as we stop through various points in the scenario. What I will say is that we recognize that all jurisdictions respond differently. We chose one crime type to focus the scenario, and we also recognize that not everybody has the same practices in place for how they respond. So with that being said, we're going to jump into the scenario. This involves an initial response to a death investigation. We have two people right now that have been identified. We have a deceased person, Esther, who's 83. We have a witness, Stephanie, who's a home health care aide that comes to Esther's home twice weekly to provide services. So Officer Thompson responds to a death investigation call involving Stephanie, discovering Esther on the kitchen floor upon arrival for her scheduled shift. Stephanie was distraught, described seeing blood near Esther's head, relayed she'd never seen a dead body before. Officer Thompson secured the scene, requested the response of the homicide unit, the crime scene unit, and victim services. So great time to jump into our first poll. So Aaron, will you kick that off for us?
You bet. Question is who has victim rights at this point? Esther, Stephanie, no one? Or indicate if you're unsure on that last one. And we'll give everyone about another 10 seconds to respond. Perfect. All right. We're getting some great responses here, Amy. I'm going to go ahead and end that poll, and I'll share the results. 41% of you indicated no one. 27% said Stephanie does. 15% indicated Esther, and unsure was indicated by 17. Back to you.
Meg, what do you think?
This is so great. So the very, very precise answer here for most of us would be unsure. And that's because we'd have to go look up the definition of victim in our jurisdiction to see, does victim status attach even in an investigation that hasn't been deemed a crime yet, right? And what I would say is you're not going to find a jurisdiction that has that broad of a definition of victim, right? It is generally going to attach when something has been deemed a crime. So those of you, the 41% of you that answered no one because the incident hasn't been determined to be a crime, are likely sitting in the best spot. Those of you that said unsure, if your brain was thinking, I need to read the law, spot on. Esther and Stephanie, I think where you all are going is a really wonderful place of the law provides the floor. It doesn't provide what we could be doing for human beings in our community. It's just the minimum. So, right, as we think about how we serve community, we might want to be treating folks a particular way, but unsure or no one would be the best answers here.
Yeah, and one thing I'll offer up is this is where the distinction between rights and services exist for me. There may be services that are readily provided to the two people there, but the legal rights may not be accessible to them, right? So we've now established that in that set of circumstances so far, the victim services response might look like, depending upon agency policies and practices and staffing levels, recognizing that some agencies may not have victim services respond to death investigations, or they may not respond to incident scenes. But if they do, victim services can review common responses with Stephanie, with the witness. It was obvious that she was having some trouble comprehending and responding to what she was witness to, right? Um, Victim services can also review investigative process, right? This might look like educating Stephanie on possible future interviews or the limitations of investigative updates if she's not considered to be a person who's entitled to receive those updates, right? Helping with employer communications. Stephanie might need someone to advocate on her behalf about why she can't finish her shift that day or why she might need to take a couple of days off. And while that's something that in my practice history in law enforcement, that's something that we would certainly do for Stephanie, that's not a right that Stephanie has in terms of victims' rights access. But it's nice to know how neatly paired rights and services are. So now we're going to step into the investigation, right? It's the preliminary contact. Investigator Truitt has now responded, and he's met with Stephanie, accompanied by victim services at Stephanie's request. Stephanie said Esther was in good spirits 3 days prior with no active health complaints. She said she didn't understand why Esther's walker was not near her because she used it consistently for mobility support. Stephanie provided contact information for Mark, who's Esther's son that lives locally, and shared that Mark rarely visits Esther but expresses frustration at having to help her. Stephanie's unsure when Mark was last at Esther's home. She provided contact information for Susan, who's Esther's daughter that lives out of state, and said she's never met Susan. So victim services provided trauma response, investigative process information to Stephanie, and Stephanie was encouraged to call back with any further needs. Investigator Truitt and victim services responded to Mark's home to deliver the death notification. Mark requested help with telling Susan of Esther's death, and investigator Truitt and victim services called Susan, confirmed she had a support person present, and delivered the death notification. And Mark and Susan were both provided with investigative information and grief support resources. And victim services then offered to help Mark and Susan with coordinating afterlife arrangements for Esther and arranged to check in with each of them in a few days. Investigator Truitt advised he would be in touch with both Mark and Susan to schedule comprehensive interviews at another time. Aaron, you're up.
All right, and time for our second polling question. Who has victim rights at this point? Mark, Susan, Mark and Susan, no one, and unsure. And we'll give everyone just about another 5 seconds or so to go ahead and respond. Well, Amy, as you can imagine, you and Meg can imagine, it's a little bit more of a distributed response here. I'm going to share those results. 44% indicated no one, 28% said Mark and Susan, 23% were unsure, 4% said Susan, and 1% Mark. So what was the right answer here?
Again, what I'll say, right? And as a lawyer, you'll get tired of me saying this. We got to go find the jurisdiction's law, right? So unsure, you're kind of in a safe place. We still don't know if it's a crime from what Amy read to us. Each of us is starting to attribute that it is a crime, right? Both from the facts we're receiving and from the fact that we're in this training, right? So we're starting to see Mark and Susan because it looks like we have a death, but we haven't seen that it is a death from criminal conduct. And so Amy's distinction between rights and services is something to pay attention to. It is also, I do want to note, right, we're starting to see that it might be Mark and Susan, right? We're going to start to think that through. So figuring out what our policies are around this, because we never want to not provide rights if someone is a victim, because that could delay them accessing those rights. But as we'll see in the facts, what if something changes along the way? So, really thinking through in your agencies what happens in this investigative phase before we have said crime, when we're just doing death investigation. It's a really important part. So, the technical right answers again are no one and unsure at this point.
Great. And then if you have the luxury of having victim services, depending again on agency practices and staffing levels, you might see those victim services show up to help with those next of kin death notifications. I have served in multiple jurisdictions where those are done in team approaches, and it has been incredibly helpful for next of kin and other co-victims to receive that contact in a compassionate communication context versus an investigation. And so that's been very, very helpful, and it's helped them stay engaged with the investigative process when they are contacted in that way. Victim services can help with additional notification. In many jurisdictions, you're only required to notify the legal next of kin, but in multiple family dynamics and situational dynamics, there are a lot of people who care about this person. And so we may need to tell multiple people about what's occurred. And certainly help with afterlife arrangements. That's something that was pretty commonplace when I was directing victim service units. That's something that people often needed help with, that they just didn't naturally have the skills or resources or the knowledge to know what to do next or what their responsibilities were. And so that's a really nice space for victim service personnel to be involved and to be helpful.
Amy, before you move on, an additional
Yeah.
bullet I think we could have added right there is this is also the space to start to think about referrals to attorneys for
Oh,
folks,
for sure. Yeah.
right? Who can start to navigate this complexity of legal definition of victim and do you have rights or not? So have that in
Yeah.
your arsenal around this space right here.
Yep. Yep. And resource connections vary so drastically based on the circumstances, but I think that's an absolutely wonderful point to draw in, is that should always be in the back of the mind of victim service personnel, is who's going to be involved, or can we get additional support for them long term to engage with the justice system. So now we're doing interviews and follow-up. Investigator Truitt interviewed Susan via virtual platform. She advised not having recent contact with Esther or Mark due to family tensions. She had questions about the probate process, and Investigator Truitt offered to have victim services contact her. He called Mark to schedule an interview. Voicemails were left on 3 occasions. He went to Mark's residence and left a business card with a note to call him. Victim services reached out to Mark. A voicemail was left requesting a return call. And then several days after the incident, Stephanie, that original witness, called victim services and said Mark texted her to meet up and return the home health care agency's property. Stephanie said Esther's walker was one of the items, and she saw blood on it when she put it in her trunk. Victim services told Stephanie to drive straight to the agency, and she would arrange for Investigator Truitt to meet her. Investigator Truitt collected the walker, submitted a request to test the item for blood and fingerprints. Victim services and Stephanie provided their cell phones to Investigator Truitt for collection of the text messages that were exchanged. And the day after Stephanie's visit to the agency, Investigator Truitt interviewed Mark, and after the interview, Investigator Truitt advised victim services that Mark is now a suspect and the death is criminal in nature. Aaron?
Next polling questions open. Once again, who has victim rights at this point? Mark, Susan, Mark, and Susan, or unsure? All right. We're seeing definitely some differentiation here in the answers. I'm going to go ahead and end the poll. Thank you all so much for participating. 52% of you indicated Susan, 37% were unsure, 10% Mark and Susan, and 2% indicated Mark. Meg, what was the best answer?
This is fantastic. I can feel through the technology folks thinking this through. Unsure if you put it there to look up the law, great job. Otherwise, what we have is probably Susan. I say probably because as if I was Mark's attorney, I'm going to be pushing back on you. But what we have is Mark's been identified as a suspect, right? And so in the legal definitions of victim all across the country, it will say a, a person directly and proximately harmed by a crime, their loved ones right next of kin. And then there's usually an additional sentence that says, but in no case can a defendant, an accused, a defendant, or the convicted person assert victim's rights. It's phrased something like that. So we now have Mark being accused, and even though it may not be formal from the prosecution through an indictment, it's starting to say he likely is not going to fit the legal definition of victim. But Susan, next of kin, is likely going to fit the legal definition of victim. So the best answer here is probably Susan, but I still give credit to anyone who's unsure too.
Great. And then immediately after that, we have another poll. Aaron, we want to throw that one up?
You bet. And what rights may be available? And you can see we've got 5 options there. All of these rights: unsure, compensation, information, fairness, dignity, and respect. So, Amy, you're right. People are getting faster and faster in responding to these. So I'm loving this.
Right.
I'm going to go ahead and close down the poll. And we have definitely a leading contender. 80% indicated all these rights. 10% said fairness, dignity, respect. 7% were unsure. 3% information. No one indicated compensation.
So all of these rights is the correct answer, right? Once we have a legal person who qualifies as a legal victim, we are going to have pretty much all of the rights at play in some way, shape, or form, right? So some of them might not look as clearly as an issue if it says something like about a court, but all of these are crystal clear that they're at issue right now. Law enforcement and law enforcement victim services are going to have an obligation to afford victims the right to be treated with fairness, dignity, and respect. You are going to have an obligation to ensure that the right to information is meaningful. You're going to have an obligation to inform them of the compensation program and hopefully connect them with someone to assist them in applying. So all of those rights would be at issue at this early phase.
And I think if you are law enforcement-based victim services, it's really important to recognize those rights and really engage with how you plan on communicating that and reinforcing that to the people that you serve. But it's not just victim services responsibility, like we said at the very beginning, right? So when it comes to fairness, dignity, and respect, the way that Officer Truitt might be able to reinforce that is to deliver the death notification in a timely manner, in person, whenever possible, with a primary focus on compassionate conversation, not conducting a suspect interview, right? So that's a way that right can be provided and be accessible to people. Victim services might also be involved in delivering death notifications, helping coordinate afterlife arrangements. I can't tell you how many people that myself and my staff have assisted with that, where fairness, dignity, and respect have come up in conversation about how they received our assistance. They very much appreciated being treated in a fair and dignified manner after something so horrific. And certainly we can take part in making sure that those things happen according to their interests, right? Which is something that we should be focusing on as victim service personnel. When it comes to the right of information, once again, Officer Truitt can certainly be involved in providing victims' rights information that usually comes in pamphlet form or you know, a barcode to a website or some avenue like that. But it can also be explaining investigation processes in a way that people can understand. It can be communicating when a crime has been determined versus, you know, an incident that they're investigating. It can be making sure that the people involved have contact information, accurate contact information for both the investigator and victim services, right? Information can be drilled down to minute levels like that. Case status updates are a big one that we hear victims and co-victims talk about a lot, about wanting consistent information. And I will tell you that victim services can be and often is very crucial in delivering those status updates. I always like to talk about them in bi-directional updates because it's my opportunity to also update investigators about the status of victims and co-victims as they're engaging with the system, right? Are there any factors or barriers that might prevent them from engaging, that might prevent them from showing up in the way that law enforcement wants them to show up? And so handling that information can be incredibly helpful, and that's an absolute right that people have in most states. Compensation is something that was pretty routinely discussed, when I was a director and with my staff. But it's also something that Investigator Truitt can contribute to, right? He can provide information about compensation. He can also ensure the availability of his reports and documentation because most compensation agencies and organizations require some level of verification. Victim services can help connect people with the application process, like Meg was talking about. And that's for incidents and financial expenses that people are often not prepared for. So in this scenario, that might be cremation or burial costs. That might be counseling. That might be specialized cleanup that may have to occur at the place where the person was harmed or was killed. Now we're going to do charges and follow-up. So Investigator Truitt has done enough investigation to determine that he's at a point where he's consulting with the prosecutor's office. An arrest warrant has been approved for Mark. Mark was arrested and booked into jail. Victim Services contacted Susan to review victim compensation, helped her register for Vine, reviewed jail and prosecution processes, and Susan requested the return of some items collected from Esther's residence. Victim Services completed a supportive handoff between Susan and victim witness personnel at the prosecutor's office. So, Aaron, you want to launch that poll?
You bet. That's a final poll. What rights might be available in this case? Confer, notice, property return, all of the above, or indicate if you're unsure. Okay, give everyone just a few more seconds here. All right, I'm going to end that poll. I'll share the results with everyone. 89% indicated all of the rights. 7% were unsure. 2% indicated notice. 1% property return. No one indicated confer.
Fantastic. All of these is the correct answer, right? If you put unsure, again, you might have been thinking about, I got to look up the law to make sure. But the right to confer is very clearly at issue now, even when it is phrased as the right to confer, consult with the attorney for the government, because we've had a handoff. We're in prosecution now. It doesn't mean law enforcement victim services is off the hook on the right, because conferral is a two-way street also, and the victim has to have enough information that they can meaningfully confer. And so that includes information from and to law enforcement and then from and to the prosecutor. So that one, absolutely. The right to be notified, right? This is again about critical stages of criminal justice. The referral and the charges, right? The referral to prosecution and then the charges, absolutely moments of notification rights. And then everything that happens after that as well, right? So that one, right, is really at issue for Susan here. Property return, right? We're still early in the case. However, right, we may need to be looking at what property was taken and is it still evidentiary, right? Does it still have an evidentiary purpose? Are there other ways that it could be preserved as evidence such that it could be returned? Because there is a right to prompt return of property. So all of these are at issue now. And again, law enforcement, you're the bridge, right? You have done a warm handoff, but you're not out of it, in large part because if you've done your job as beautifully as you usually do, the victim's going to be a little attached to you. And so continuing to ensure that they have access to their rights is a really important part of the job.
Great. So we're gonna just talk through some ways maybe that can happen, right? So when it comes to a right to confer, Investigator Truitt can actually be involved in this, right? By reviewing the prosecution process and making sure that people understand the disposition of the law enforcement case itself. He can prepare them for the ability to confer, to provide information, to actively engage, to give them information about the space and time with which they can ask questions and provide information to the prosecution. Victim services can also be really helpful in this way. Um, those supportive handoffs that we mentioned to victim witness personnel, I can't tell you how essential those were in every jurisdiction that I worked, so that people didn't feel as if they were dropped at certain points in the process. Sometimes it can take a minute by the time the case gets referred before it's scheduled and before people start meeting with them to collect additional information or to update them. And so it's really important for law enforcement victim services to connect them with the people who they can easily access at the prosecution office to get their questions answered. I would try and have my staff do those on joint calls whenever possible so that there was a formal introduction, not just telling the victim somebody from that office is going to call you, right? Actually introducing them to a human being so that they would have a face and name to communicate with. It would also be important for my staff victim service personnel to review participation options and expectations. I used to have a ton of people that get confused about subpoenas and am I required to be in court or can I go to court? And those are two very different things, right? And people's preferences and desires vary around those. So us being able to provide information to them about how their right to confer looks in those jurisdictions and those practices within those jurisdictions is important. Property return. This is a space where I could proudly say that when I was working in victim services in law enforcement, we took on this initiative, right? Because we knew that it was a right that people had according to victim rights laws in our jurisdiction. But it was also something that we worked with our sworn peers with pretty consistently. So Investigator Truitt, part of how he can contribute to this right is to consult with the prosecution office about the status of those collected items like Meg mentioned, right? Are they still needed for prosecution? Are they still of evidentiary value? We saw this change pretty significantly during the pandemic because people were relying on capturing evidence in other forms to making sure they were available for the court, not necessarily retaining the physical item itself. And so if there's any leeway or if there's any, ability to be flexible with that, the investigator can kind of lead those conversations with the prosecution to determine that. They can coordinate the release of items that are not needed to the rightful owners, right? And that can be a proactive thing and not wait for victims to kind of raise their concern. Victim services, absolutely, I think this is a great space to be involved. Getting property back from law enforcement is really not a pleasant process for most victims, right? They have to show up at the darkest, ugliest corner of the building. It usually looks like a jail cell. It's smelly. It's not well lit, and then they have to fill out a bunch of paperwork and they get handed this bag back that has evidence stickers wrapped all around it. And it's sometimes in this particular set of circumstances, it might be items that were of sentimental value to their loved one that just died. And so we, as victim services, can be incredibly helpful in making sure they have access to the right to property return in a way that's dignified and respectful, right? So we can help coordinate those arrangements in times and places that are helpful or beneficial for the people that we're serving. We can certainly accompany people during property returns, and I will tell you that my staff, upon doing that, victims and co-victims found that very, very helpful to be accompanied and prepared during that process. We also made arrangements for those property returns to occur not at the property desk counter, right? But we made arrangements for the property to be repackaged into neutral packaging when that was called for, when there might be blood or you know things that may cause a response from the people receiving the property. We would repackage in neutral packaging, and then we would give them back property in a soft interview room or another setting. So I think there's ways to think about how to make sure people have access to this right in a way that's going to be beneficial to them.
And
Certainly the right to
Amy,
notice. Oh
sorry,
yeah,
Amy, if I
Meg.
can, before you move on, I think what you just shared was really important, and I want to lift up one thing that is important there is right. Every survivor is going to have a different approach to how they want things back. So I've worked with many of my clients who want it back intact, how it was, like how law enforcement took it, including blood and things. And so really having on the return of property, wrapping in the dignity, fairness, and respect part of that to have the conversation first with the family or the victim and say, we can get some property back. How would you like that? Because here's the trauma moments, here are the non, and really wrapping together dignity, fairness, and respect with return of property as the way you always did it, Amy, I think is really important.
Yeah, yeah. And there were times when we would return property in its original packaging, but we took into account what that was going to look like to the people receiving it. And so that was something that we were just thoughtful about and worked very closely with our property personnel and our investigators. So when it comes to notice, Investigator Truitt can certainly be a part of this and review prosecution process, ensure valid contact information. I know in my work, people moved a lot, and especially after criminal incidents, we would find people move to different locations. And so making sure that prosecution personnel had up-to-date contact information for everybody was important. Um, it Victim service personnel can also contribute to this by making sure that those supportive handoffs are really productive and comprehensive, reviewing participation options and expectations, updated contact information, making sure that when there's a gap in time and they recontact victim services at law enforcement, that we can reconnect them with the prosecution office when it's appropriate. So just making sure that the system keeps up with the people that are impacted by the system. And then Meg's going to take us through some last minute reminders, and then we're going to have some questions.
Yeah, I'm excited to get to the questions. So again, just a refresher. You all did great as we were going through the scenario, and you started to identify the rights and you know to look them up. And we have a lot of questions we know. So just a few grounding things. One, you at the law enforcement moment are the key to victims having a positive, the best, most positive experience they can have in the aftermath of victimization. And the access to rights, you promoting access to their rights is absolutely critical to effective response to crime and to services for the victim. So you really are the key to all of this is making sure you know the rights and you can afford them. And you can afford them by making sure that you do so in a trauma-informed way, right? So you put together all that trauma-informed training that you had with the knowledge of the rights in a way that is individualized to each victim. Whatever they are coming to you with, you need to figure out how do I afford rights to them as an individual. And I would also say in a way that they want, right? There's an apostrophe on victims' rights. They own the rights. So talk with them about how they want the rights afforded. And then rely on your knowledge, but also your partners. And second one, the one that is on the right-hand side of the screen, get to know your law. There really are jurisdictional differences around the rights. Best practices and services, those can transcend jurisdictions a little easier, but the rights themselves, we have to look at every word in the law. And so get to know those. And if you ever have questions, ask, right? Ask before there's a survivor in front of you. And so that you can afford them in the best way possible. So those are kind of your reminders for everything you do that Amy just talked about.
Yep. And then we're going to have some helpful resources. We include these in every webinar. You will have links to this PowerPoint. You can download it off the Justice Clearinghouse website. There is an eLearn project at the IACP that really talks about law enforcement response, and I mentioned that it's like top to bottom, side to side, all four corners of law enforcement response. There's also some pretty great work that they've done around law enforcement based victim services in particular, and so there's a ton of resources on that website. Meg's organization, the National Crime Victim Law Institute, I can't tell you how many times I'm helping a law enforcement agency in a particular jurisdiction, and I pull up the rights that they've worked so hard to develop by jurisdiction, and we have a very specific conversation. So you have access to those. My organization, the Integrity Institute, there's a ton of resources, services, stuff that's been developed around law enforcement-based victim services. We have one more Justice Clearinghouse webinar happening this year, so you'll have information to that. I did notice somebody asking about access to this webinar afterwards, and I will shout out Justice Clearinghouse at this point. Part of what I've done in my fellowship with OVC is they've asked me to develop some law enforcement policy templates around particular topics that include how to involve victim services in the role of that practice. One of those was victims' rights. And so I'll be following up and sending out that resource to everybody. But in addition to that, Justice Clearinghouse has also said that they would be on permanent loan. This webinar will be housed on my website that anybody can access it at any point in the future if they want a reminder about victims' rights. And then if you want help as a law enforcement agency from me, just to dive into topics in the future, you can reach out and connect with me. My fellowship, we do free virtual assistance. It says through September. I will tell you that's been extended to March of 2026. So feel free to reach out and I can help you dive into particular issues that you're having. And then we are going to open it up for questions. I see that there have been a ton flying through. So,
There have
Aaron,
been.
I'm going to leave it in your hands to kind of pick which ones you're going to present to us. And what I will say is that if you all have identified yourselves in that Q&A and we don't get to it, Justice Clearinghouse will send me those after the webinar today, and I'll follow up with you individually.
Outstanding. Amy, Meg, thank you both so much, folks. I appreciate all the amazing questions that you've submitted. We'll try to get through as many as we can, but again, please do reach out to Meg or Amy if we don't get to your question or you have follow-up questions. As you may have seen, I'm going to drop that into the chat right now. Our next webinar, our final webinar in this series of webinars on victim assistance is on August 28th. It's the VSU Response to Victims and Co-Victims of Violent Crime. We'd love to see everyone there. Again, you can click on that link or go to the Justice Clearinghouse website from the webinar schedule. Find August 28th and you'll be able to enroll. All right, Amy, Meg, if you guys are ready, I'd love to work our way through these questions.
Ready?
Ready?
Perfect. First question comes from Beth. Are there income requirements for compensation?
No, there are not income requirements for any of the crime victim compensation programs. So the victim does not have to be below poverty level or any of those income requirements. There are different requirements for accessing, like when you apply, how you document, all of those kind of things. They're available on each crime victim compensation's website, but the victim themselves does not have an income moment.
And one other thing I'll offer up, I think a lot of people make the assumption that compensation comes from like tax dollars, et cetera. And it really is, it's sourced through offender fees mostly. And so it also is a program in most jurisdictions where it's a payer of last resort. So they expect you to tap into available resources, but there's no income requirements in any of the jurisdictions that I'm aware of.
Outstanding. Thank you so much. Okay, next question. Do you have any suggestions for how to approach conversations around the need for a list of attorney referrals with my police department chain of command? We often hear that an issue is a civil legal matter and that we are not part of the criminal legal system, so we should not wade into those waters.
Yeah, I can tell you I have experience with this. I was a director of a law enforcement victim service unit. And I think first and foremost, I think you need to be familiar with laws in your jurisdiction, if there are any that prohibit that kind of activity coming from law enforcement. The concern as it was presented to me was that we didn't want to be in a position to recommend legal services of one firm versus another firm versus another firm, right? We didn't, as a law enforcement agency, want to get into preferred connections with people who could also be financially gaining from that same interaction. What I will tell you is there was also confusion about civil legal services and victim rights attorneys. And so I had to do some internal education with my own agency about referring to victims' rights attorneys, making sure there was a list of services available for people who needed civil legal assistance stemming from the criminal incident. And that might look like custody, that might look like immigration, that might look like things where they needed legal representation, but it wasn't directly legal representation of the crime, if that makes any sense.
And if I can add to that, so actually NCBLI is about to come out with a resource that really explains each of the types of lawyers that a victim may want to or need to interact with. When it comes to referrals, a lot of folks are anxious about giving referrals. The general rule from Executive Office of U.S. Attorneys all the way to most states' attorney general who have been asked the question is that the provision of 3 names is always sufficient to ensure that you are not recommending one. Better practice even is to refer to agencies where there's a grouping of lawyers. So the State Bar Association will likely have a grouping of lawyers, but also I will just say NCBLI has an online portal where victims can be paired with lawyers. So you can refer them to NCBLI and we can start getting them paired if there's a lawyer in the jurisdiction. And again, though, it'll depend on the type of lawyer, right? Civil legal assistance versus victims' rights enforcement, they can be the same lawyer, but they're often different. Happy to do a deeper conversation about that at some point too.
And I will tell you, Meg, that's exactly what I did in the jurisdictions. We created resource guides and we literally listed every attorney possible in our jurisdiction and just handed out a sheet to people and said, it's up to you to connect and call whomever you'd like to call, right? So we weren't in the business of recommending anyone. We just made resources available to people.
Great, thank you both. Jennifer has the next question. You mentioned victim rights to understand their constitutional and statutory rights. Any suggestions when working with victims with mental health or addiction issues?
So I'm hearing the question as being one about when those are the victims who might have trouble accessing due to their illnesses, their rights. So those, again, all the more important to have referrals in your location. Someone in also asked what jurisdiction means. Jurisdiction is just the area you work within. In law, it means right the court I might be in or the prosecutor. So jurisdiction is just a fancy legal word for location, basically. So having referrals, what I will say is lawyers have started to be trained on how to work specifically in a trauma-informed way with clients with mental illness and addiction issues. And so, you're going to want to make sure your referrals are going to places where they have had some specialized training. That all of that said, I want to emphasize one thing. It doesn't change the fact that they're entitled to rights. The fact that someone has mental illness, the fact that someone has an addiction, the fact that someone has other disabilities or differing abilities, none of that affects that they're entitled to their rights. What it affects is our obligation to provide the rights in a meaningful way, which often means partnering with folks with expertise.
Great. Kelly asked a very similar question. It might have the same answer. How do we notify a victim of their rights if they have cognitive impairment? Through a power of attorney or a guardian? What if they don't have one?
Yeah, so I'll step into this because I do think that sometimes those issues get confusing for people. just because somebody has an impairment or has a mental health diagnosis doesn't mean that they have their rights taken away as an adult. And so it may mean that they have a case manager, it may mean that they have an advocate from another organization that's working with them. But that's up to us to determine how to effectively communicate with them while their rights are in place, right? There are a lot of vulnerable adults who have cognitive issues, who have mental health concerns, who don't have legal guardianship over them. That means that we have an obligation to communicate with that individual in a meaningful way. And so make sure that you know who you're communicating with, make sure you know what resources of support they have accessible to them, but also make sure that you're not erasing them from the process and only communicating with other people because it's challenging, right? You still have to step up and communicate with the person you're serving in a way that's meaningful, in a way that is dignified, in a way that protects their rights as an adult.
And I would say one practice tip there, take care of yourself if it becomes a really challenging situation. But B, when we have folks we're serving that have differing abilities, right, or are navigating different things, checking in with them and finding devices that allow them to tell us more what they're hearing and what they're understanding, it becomes all the more important so that we can pivot, right? And so reality is those victims may take a little more time to serve, but we still have to serve them because they have the rights. And again, building community support is really important both for yourself and for the survivor.
And just a technical caveat, power of attorney is not the same thing as guardianship. And so it's really important to understand status differences and not make assumptions that because somebody has a power of attorney that you can't engage them in the process and talk to them, right? Like you really do need to understand the status of the people that you're communicating with.
Regarding the status, one more question related came in from Cindy. How do you navigate a situation where the victim is undocumented with limited rights here in the US?
So I always partner with an immigration attorney when I am doing it, just to make sure that nothing I am doing is negatively affecting their other rights, because I'm an expert in victims' rights as they navigate criminal justice. And I am not an expert in immigration law. So I always have to have an advocate and an attorney in that space, and we collaborate. Um, Victims' rights don't detach based on status, right? So that is not a part of the legal definition of victim. So victims have rights regardless of their status. And survivors need to know the ramifications of engaging in the criminal legal system, which is they may be fact of their presence may become more widely known, and that may negatively impact them in a different way. So the key about victims' rights is you figure out if they apply, right? And then the victim owns them. Again, there's the apostrophe. And they need to knowingly, voluntarily assert those rights or knowingly and voluntarily waive those rights. That means they need to understand the ramifications of asserting their rights. So if asserting my right to crime victim compensation is going to negatively affect me in some other way, including my immigration status, I need to know that before I apply. And so again, it can get pretty complicated in those situations. So having partners matters. But the key is the rights are owned by the victim and they have to know the ramifications of asking for them on the rest of their lives.
Great. Next question. I think it's directed to you, Amy. What does neutral packaging look like?
Yeah, this can be challenging, right? But what I will say is most law enforcement agencies use some type of plastic packaging typically, or they'll use like brown paper packaging. And then what I have found to be most offensive to people is like these evidence stickers that get wrapped all around it, and there's, these the just the insignia that it was connected to a criminal investigation sometimes will upset people. So we would do very simple things like we would go out and buy manila business envelopes sometimes to put smaller items in, like pieces of jewelry, or even those little brown paper um, lunch sacks that you use for kids at school, right? Just something that wasn't stickered up, and then we would connect our victim services contact information onto the packaging so that they knew how to reach back out to us. It doesn't have to cost a lot. It doesn't have to be something that is a huge expense. What it does do for me, what we try to do is remove anything that would cause them to be further harmed by seeing it again. We also, there were times where I mean, to be very, very frank, there were pieces of property that came back with biohazard material on them. And so we would do our best to try and remove that if possible, if that was the request of the family, so that they didn't get a piece of item back that had, you know, a blood stain all across the shirt. Or, we would talk to people about the status of the items to see what their preferences were about how they wanted to receive those and what that looked like. So I think it's really, really important just to talk with the people that you're serving and prepare them for what's happening, and then say, how would you like to handle it? These are the three options that we have. But neutral packaging sometimes just to me, that's removing any indication that there's an investigation taking place. If it's been determined that it's no longer of evidentiary value and it's able to be returned, it's no longer evidence. It's somebody's property. And so just return it to them in a dignified way.
Okay, great. Another property-related question from Jessica. Defense counsel tends to be a common holdup in property being returned due to evidentiary value. If prosecution has consented to its return and is done with it, is there a specific time for defense to respond? When does the timely manner clock start?
So I will tell you that every victim's rights statute that I've read about property return doesn't have the level of specificity that you're looking for, right? There is no definition for timely. That's a that's a jurisdiction, term that people determine. What I will, from my experience, is that prosecutors would not give permission to release if they also haven't conferred with defense counsel. They're not going to do that separate from defense counsel. They usually do that to make sure that it truly is okay to release. So timeframes vary. In particular, I remember responding to a sexual assault case, and the female was sexually assaulted on the couch of her home and happened to be sexually assaulted on a baby blanket that was a family heirloom. And so she was very, very, very insistent upon getting that back, but had to prepare her that the prosecution wasn't willing to release that until all final appeals on the case had been exhausted. So we were talking many, many, many months into the future. And so that was just a tough conversation that I had to have with that victim.
And I would say this is the exact moment, whether prosecution agrees and the defense doesn't or not. This is I cannot tell you how many times I've gone to court and I've been able to, because I can push as the victim's lawyer, either I or one of my partner lawyers can go to court and say, prove to me that it has evidentiary value still. And why can you not take, and actually, Amy, I had a blanket case also. We consent to you keeping a square of the blanket where the semen actually is, but you're returning the rest of the blanket. So we're consenting to damage to property and return now. And the court said, defense, prosecution, why is that not sufficient? And they had a burden to show, right, why it wouldn't be sufficient. And right, we have so many opportunities now for evidence preservation that we didn't have in the past, and many of our law enforcement and prosecutors simply haven't thought through the creative ways of preserving evidence that allows for return. And so that's the exact moment to have a creative advocacy moment that includes a lawyer argument that puts the burden on the person saying they want to hold it to prove why it's still evidentiary. And we've succeeded in getting most property returned.
Okay, I'm going to try to squeeze in one more question from Justina. For weekend advisements, what happens if the DA's office does not reach out to the victim prior to the court hearing?
That's for me, that's a great space. Why there's attorneys like Meg and her team involved, right? I do think that that happens more often than I would ever care to say I'm okay with. And if you know that that's happening in your jurisdiction, try to prepare victims for that ahead of time, and say, we don't know when it's going to be called. This is what's coming. Make sure that you're aware if you want to be engaged, you're going to have to do a little self-advocacy, right? That's not an ideal situation, and that's certainly not something that in an ideal set of circumstances would happen. But I promise you, part of my job as victim services was me teaching the victims about the system and how to show up in the spaces that they wanted to show up in. And then Meg, I'll turn it over to you.
Yeah, spot on. It happens every weekend all across this country. And it is a violation of the victim's right to be notified in almost every jurisdiction. And so then we're like, how do we prevent it? Because we are low on resources. Defendants have rights that require arraignments at a certain time, right? And releases in a certain time frame. So figuring out, how do you prevent it to the best of your ability? How do you prepare the victim to show up if they can, regardless? And putting in place systems that allow for additional information after that first hearing. So, Oregon, for instance, we have a right, it should be happening. However, if the first hearing happens and there is a release, we have a specific provision that says, and the victim can ask for another hearing. We didn't need that provision. We could have done it anyhow, but we made it so that everyone in the system knows if you failed to notify them, the victim gets to talk still. So figuring out how you might be able to navigate to that space would be good too.
Fantastic. Thank you both so much. Any closing comments you'd like to share?
For me, I just think if you are in a law enforcement agency, my initial thought is, if you are a sworn person, don't just assume that you can hand off all these responsibilities to your victim service personnel, because actually you can be an effective conduit of victims' rights access. And so don't just make the assumption that because you have the luxury of having victim services, you don't have to be involved in the rights conversation. Because sometimes the processes that are in place, you hold the door to whether people get access or get invited into the room. And so you have to be part of the conversation. For victim service personnel who work in law enforcement, I can't tell you how important I think it is that you absolutely know victims' rights backwards and forwards in your jurisdiction. That is your gateway to making sure that people get really solid, accessible, victim-centered, trauma-informed services. If you did nothing but make sure that every victim, every co-victim who had legal rights got consistent and proactive access to them through your policies, practices, and actions, you would be delivering optimal services to everyone. So dig into the rights and figure out what spaces in your agency they show up, and then work towards making that accessible to people and making sure that you've got the resources and the support in those intersections to make sure people get access to their rights.
I will just end with a thank you for being interested in this, committed to the work, and also noting you're not alone. This is a hard space to be in. And on this training alone, we have more than 400 folks. So there is a national community trying to figure this out. Amy's helping lead that effort. So ask for help, but also share your resources. Let's continue to build victims' rights at the law enforcement moment, because that's the only way we can really serve our communities.
Fantastic. Meg, Amy, I can't thank you enough. What a wonderful presentation. To our audience members, thank you so much for taking the time to join us today. I know that all of you have probably overwhelming caseloads, and it means so much that you're taking time out of your day to visit with us. With that, this concludes this morning's Justice Clearinghouse webinar. Take care, everyone, and please stay safe. Bye now.